And it's interesting that Canadians are much more sensitive to this issue than just about any place in the world, although Europeans are coming pretty close. Canada has, I learned an interesting statistic or an interesting fact from somebody who has been in the technology industry for years on both sides of the Canada-US border, that Canada has always been at the leading edge of the adoption of different models of computing and different kinds of technology. But actually, when it comes to cloud computing, Canada is trailing. And it's principally because of this privacy and security issue that is really quite complicated and really requires a pretty nuanced understanding of what the issues are in order for an organization to make the decision for themselves whether they can go all in or part in or how to go or what different models of cloud computing can be adopted. So also as a bit of a preface, I think it's mandatory for a lawyer to throw up a disclaimer, but I do want to give you a sense of kind of where it is that I'm coming from. I represent cloud computing providers. I represent cloud computing customers. I've been on both sides of the discussion when it comes to this topic. And so what I'm hoping to provide answers to your questions and a little bit of educational background and things like that, additional context to help understand what is a pretty complicated and messy area of the law. And it would be very difficult, I could write a book on this, but it'd be very difficult to kind of plumb all of the issues in the limited amount of time that I have. But I do hope to be able to make sure that you don't walk out of here with any unanswered questions. And it should also be noted at the beginning that there aren't answers to every single question, but I'll do my best to help kind of convey some additional understanding. Now, I don't think I have to go into the fundamentals or the very basics of computing 101, but cloud computing is essentially, it's a model that is kind of going back to the beginning in a sense, and I'll talk about that in a couple minutes. But essentially it's where most of the computing power takes place somewhere else. It doesn't take place on your desktop. You're connecting to another system, and it can be a network of servers, which is the case with Google and is the case with Microsoft or Oracle or others. Salesforce.com, where your device is actually just a way of accessing or connecting to data that is somewhere else. And it's called the cloud because you really don't know where it is. It's just kind of amorphous thing that you connect to usually through the public internet, preferably through a secure tunnel, but it really doesn't matter what hardware you're connecting to because you're using standard protocols. The key thing is that most of your data is not on your device and most of the computing power does not take place on your device. And I should mention that this full presentation is going to be available on my blog. If you want to have a copy of it, it's at blog.privacylawyer.ca, which was also, that's the address that's mentioned in the announcement about this. So if you had the information to get here today, you hopefully have the address for my blog. But I'm going to kind of skip through that long-winded definition. But there have been a whole lot of people who have given thought to really what is the cloud in a pretty kind of theoretical way. But at least for the purposes of my discussion, the principal characteristic is that there's resource pooling. Your information is very often intermingled with other people's information on a diversity of servers. And the key thing is that your information is generally not sitting on your device. And in many cases, that information is not sitting on a device that's under your control. It's not in a rack of servers in a basement data center on campus, or even necessarily in your own country. You don't necessarily even know where it is. But that is the model of cloud computing that I'm going to be talking about. And obviously there's a huge amount of appeal. There's a reason why everybody is certainly all the universities and colleges in Canada are looking at cloud computing as a new model of delivering computing services to faculty, staff, and students. In many cases, probably in just, I can't say every institution that I've visited and spoken to, but I think every IT manager who I've met who works at a post-secondary institution really wishes that they could provide more resources, more computing power, more of what it is that actually students are expecting when they come onto campus than the existing funding would allow them to do. And it's not something that they can deliver, generally speaking, based on a solution that's offered, hosted, and licensed from their premises. The discussion about email storage space, I think, is a pretty acute one. When you're Microsoft or Google or Oracle and you're buying hard drives, 4 terabyte hard drives by the crateful, you get a pretty good price, and you can offer a huge amount of storage on demand to this enormous diversity of customers. But one of the key constraints on a campus is providing that storage within the data center that exists on the campus, where the cost per megabyte is significantly higher than somebody else can deploy it if they're buying them by the bushel. I don't know what the collective noun for hard drives is. But it's a different economic scale, and so cloud computing provides the ability to take advantage of these massive scale in computing power and in storage and otherwise, where the network becomes the computer and the cost per user can be pushed down dramatically. And it's interesting, we were talking at lunch today about kind of, UNB was really on the cutting edge. In 1984 was the first university in Canada to offer email addresses, individual email accounts to students. 1984. First-year students weren't even born in 1984. Like this is something that the generation of students who are coming in have very different expectations than certainly they would have had in 1984, where this was a completely novel concept. In most cases, the students walking onto campus use Google Docs, use Microsoft's Hotmail, use all these other collaborative platforms that could never be economically deployed on an on-site solution on a university campus in Canada. It simply, it couldn't be done in the way that it's being offered in these, what it started as, or in many ways, started as either a consumer product that went enterprise or an enterprise product that went consumer, and has become something that cuts across both. And so, but it's extremely attractive based on the economics, and it's particularly attractive based on the economics of the fact that Microsoft is prepared to offer student email services for free in most cases, and Google is prepared to offer it across campus, student faculty and staff completely for free. And the idea behind that, and I can't see into their minds, but the expectation is that if you get students using these tools now at universities, they will expect them in their workplaces, and they can hit their employers up for the licensing fees or for the per seat fees in the future. And so you guys get the advantage of it in the same way that software publishers have always offered, or as long as I can remember, most of them offer educational and student discounts because they want the students to use the good software at university and then get to their employer and expect to have that same level. And there's another aspect to it, it's greener. If you operate, Facebook has one of the most environmentally friendly data centers in the world. If you operate an enormous data center which consume massive amounts of electricity, with that enormous data center, you can put into place significant efficiencies that nobody in a smaller scale data center on campus are able to use. So if you're concerned about kind of carbon footprint and other things like that, it doesn't make sense anymore to operate a data center within a company, unless it's a data center company, or to operate a data center on a university campus. So there's so many reasons why there's this kind of big push towards cloud computing. And in a way, we're looking at it going back to the beginning. There are probably people in this room who used time-shared mainframe computers. There's simply the cost of a computer, where a computer was the size of a shipping container. You could not give each faculty member of the computer science faculty their own computer, or the economics profs or the particle physicists who needed access to computing power. You simply couldn't provide them with their own computer. They took turns on a time-shared mainframe, an enormous computer that the institution would invest in, and they would all kind of take their turn on it. Some people would kind of be there, they would have between 3 o'clock and 4 o'clock in the morning, and they'd get up in the wee hours in order to do that. And so then we saw a move towards corporate mainframes and mini computers, again, where the computing power was shared, and the way that you had access to it was through a terminal. And then the big revolution that happened was personal computing, where the cost of computing power went low enough so that people could have it on their desktop. And then all of a sudden, data went from being in these mainframes and in these computer centers onto the individual desktops. And we're reverting back to a model where the data is no longer resident on that, because the computing power, the maximum computing power, is in the network rather than on the actual device. So you start with dumb terminals and somewhat smarter terminals, which I saw this model actually at Dalhousie the other day. I was surprised. Personal computers on the desktop, and now this is what everybody's starting to expect. Laptop sales and netbook sales are outstripping desktop sales significantly, and mobile devices are as well. And one thing that's phenomenal, this device here, this is a Motorola Zoom, has about the same computing power as an iPad 2, has more computing power than the main computer on the flight deck of the space shuttle. because that's a 20-year-old, 30-year-old technology. And so even with this amount of computing power, it is principally used as a terminal in order to get access to computing power that's elsewhere. Likewise with these new dual-core smartphones. And the latest innovation are essentially netbooks or computers that are nothing but browsers, essentially terminals that provide access to very rich environments such as the Live at EDU through the web portal, because all you need is a web browser to do it, because all the computing takes place, other than showing the picture on the screen, all the computing takes place someplace else. And so we're seeing the end of an era. Now, there's still computers on desktops, and there's still racks of servers in basements, but we're seeing a phase out of that. And most of the computing products that individual students use before they get to the university are cloud products. If you think in terms of Gmail and Hotmail and Yahoo, many are used to, and I've seen my sons who are in elementary, junior high, and high school using Google Docs and other online cloud products in order to put together their presentations for science class or history class or whatever. We're also seeing on the telephony side, you can sign up for voice over IP services using the SIP protocol. Like there's so much that is happening that's available online where all of the computing associated with that is not happening on your device. Facebook is essentially a cloud computing service. All you need is a browser, Flickr, other things like that, Google+. And then you have niche ones that are really having Salesforce.com, which has a huge amount of horsepower, which obviously is quite popular in New Brunswick these days, related to customer relations management software. Again, most of it happens in the cloud with particular plugins to your enterprise software. So much of what has happened historically on your desktop, where your data was sitting on your desktop or was sitting on a shared file on a server in your organization, in the data center, is all moving into the cloud. Just about every bit of software, other than the very specialized software that are used by many kind of faculty members in the more technical and engineering fields, almost all of it has an equivalent in a cloud product. And so things are moving in that sort of direction. So those are the benefits or the drivers and the economics behind it. Well, what are the privacy issues? And the privacy issues come up principally because your information is no longer under your direct custody or control. Now, if you have your own desktop computer and you have your own personal data on it, you know exactly where your data is. Your data is on your desktop, or if it's on your laptop, it's on your laptop. If somebody wants to get access to it, either they hack into it, which happens probably more often than you would think, or they have to come and physically take the computer off your desk or take the laptop out of your briefcase or otherwise. If that information is on a shared server, which happens a lot in organizations, universities, businesses, and otherwise, somebody has to come knocking on the door in order to get access to it, although things can be hacked into and servers can be stolen, even in some pretty flagrant examples of somebody walking into the Canada Revenue Agency looking like they're a technician and walking out with a server. But these sorts of things happen, but there's a psychological thing, there's a psychological issue, aside from the legal sorts of and legal responsibilities, there's a psychological desire that most people have to be able to physically touch the device that holds their information. And if it's your own personal computer, there's a comfort in knowing where that is. If you're an IT manager, there is at least this has been my experience, I don't know if it's pervasive in this institution, of liking to go down, opening up the door, opening up the cage and seeing the blinking lights on the server and knowing that the lights are on in somebody's home, but at least you know where that device is. And so, but in a cloud model, you don't hold your information. You can't go and look at it. Sure, you can log into an administrator control panel and understand that it's using 750 terabytes or whatever, but you don't know physically where it is, because in many cases, it's distributed across a number of different servers, a number of different storage racks, and a number of different data centers, potentially. I know, for example, the Google model takes data, strips it out, strips it up into chunks, and spreads it apart across at least 3 different data centers for security and redundancy. So you don't know, and actually they couldn't tell you without getting down to a pretty base level in the code exactly where your data is. And for some people that causes apprehension. Where it comes to kind of legal and privacy issues, it's that you have an obligation. This institution does legally under law You have, as a custodian of your own information and as the custodian of other people's information, you have a legal obligation to secure your data. If it is sitting on your desktop, you feel that you are fulfilling that obligation. If you know where your laptop is, you feel like you're fulfilling that obligation, and if it's behind a locked door in a data center, you feel like you're fulfilling that obligation. In a cloud model, you're handing that over to somebody else and asking them to do it on your behalf. And you're asking them to manage that information as well, which requires, no matter what, a leap of faith, but also has legal consequences, because under law in Canada, the initial custodian of that information remains legally responsible for it. They can hand it over to somebody else to take care of it, but they can't delegate the legal responsibility for it. And so there is also the psychological element of if I'm where the buck stops, I need to be the one who does it hands-on. Which the reality is that Microsoft and Google and Oracle and Salesforce have way more people, way more resources to devote to the security of information in any form, particularly electronic information, than able to muster. And so it's likely that they can do a whole lot better job, even if this organization, this university is doing the best job it possibly can. It simply doesn't have the resources that anybody in IT would tell you that they would really want to have in order to do a perfect job. And also recognizing that there is no such thing as a perfect job. Where it becomes an additional issue or wrinkle for Canadians is the fact that when you hand over your information to Microsoft or Google or to Oracle or some Salesforce, that information is it's not in New Brunswick. It's likely not in Canada. Actually, the likelihood that it's in Canada is currently zero. It is someplace outside of your jurisdiction. And so that raises the issue of whether or not you're able to fulfill your responsibilities to secure and safeguard that information when it's no longer within the jurisdiction to which your laws apply. And there's also the wrinkle or the aspect of that as soon as information is someplace else, it's not only subject to your laws and your obligations, it's also subject to the laws of the jurisdiction where that information goes. And so what sort of impact does that have on your obligations and on the risks to that information, and can you in fact hand that information over? Also, there's a paradigm or a sense that these sorts of products, because just about everybody in this room, if I were to ask you to raise your hand, so everybody in this room is a Microsoft customer or a Google customer or both. And you're used to, when you install software, or you sign up for a Gmail account or a Hotmail account, you're presented with terms of use, terms of service. I'm willing to bet nobody in this room has read them end to end, maybe one person statistically. When I ask my law class at Dalhousie Internet and Media Law class, every year, nobody raises their hand to that question except for one person. That's always the kind of the one person statistically who's done that. But people are used to, they see a whole bunch of fine print, they click I agree, they hope for the best, and they don't appreciate what it is that they're handing over, and in many cases, they may not fully understand what it is that they're, if they were to read it, they don't fully understand it. Because they might not understand all the underlying technology, might not understand the law, might not understand the legal lingo and stuff like that. But you're used to consumer-based services where it's take it or leave it, where you have no opportunity to negotiate that, which is not in fact the case with these large-scale universities in Canada. Actually have more bargaining power than theoretically and economically they should, because these companies are very keen to have Canadian customers and are keen to deploy their products, and there is in fact room to negotiate these sorts of things. And then finally, your information or data may not be portable, and this is an important thing to think about. In this particular model, the Live at EDU model, you can take your data with you. The students can do that. But a lot of consumer products and otherwise are kind of, once you're in, you're in. That's part of their business model, is they sell it to you. They give you all the happy talk, you get your information in there, and then it's so hard to take it out that you're kind of stuck with them. But that's not the case in this sort of model. And in fact, of developers who go under the name the Data Liberation Front, whose only job it is to make sure that you can take your data out of every single Google product and you can take it somewhere else and use it somewhere else, so that you're no longer kind of held hostage to it. And that's an important part of control, because you need to not only be able to stand up and say, no, this isn't working for me, and I'm out of here, and I'm taking my data, and you're not keeping it because you can't, because I continue to be responsible for it. We don't often hear about the privacy benefits of cloud computing. And I've alluded to the fact that Microsoft and Google can have much more secure data centers than any university in the world could ever hope to muster, primarily because they have more resources for security. They also, because of the way that their platforms are designed, in many cases have better auditability. And for a number of computing models, the best way to keep security is not only to make sure that the front door is locked, but you're keeping track of who is doing what within the system. One of the most significant threats to security of information is insiders. It's either people not intending to be malicious, but in fact exceeding their access, or doing things that they simply should not be doing, and they know it for malicious purposes. And these large-scale platforms are more auditable than it would be if information is in a whole bunch of different pockets all over the place, and A, you have no idea where it is, and B, you're not able to essentially manage it when it's sensitive information. But for me, one of the most important security benefits, and security and privacy go hand in hand, is the fact that data in a cloud model is not easily lost. You hear about the Sony hacking scandal, and you hear about ChoicePoint, and you hear if you keep track of all these different privacy breaches, certainly a significant number are caused by hackers, and a significant number are caused by very weak security and really bad passwords that people use. But the ones that actually cause some of the most significant angst and potentially most damage, and some pretty wide scale and pretty horrific privacy breaches, are people who have data on portable devices and lose it or have it stolen. One of the best examples of this, or best, that's not the right word, one of the most horrific examples I have of this is a very well-intentioned employee of the US Department of Veterans Affairs. They are in the process of completely revamping their entire enterprise management system in order to provide better mental health and healthcare services to every single US veteran. And he wanted to tweak his new design. And in order to do that, he downloaded the entire production database onto a laptop and took it home to work on it. Because he wanted to do a good job, he wanted to be able to work on it. They did not have the facility so that he could do it remotely. So he downloaded the information of more than tens of millions of US veterans who are receiving mental health services and health services information, their social security numbers, the detailed information about their health conditions, mental health conditions, their relatives, their blood type, all this other sort of stuff. And he left it in the back of his SUV in the driveway of his house. The window was broken, the laptop was stolen. And so all that information was taken. All that information was gone. And thankfully, at least the investigation showed that the person who stole it only wanted the laptop, probably didn't even know what the data was. But there's litanies of other stories. Somebody, a research scientist from one of the research hospitals in Toronto lost a thumb drive in the airport in Toronto that had health information, health research files on dozens and dozens of kids involved in a health study. And that's because people want to be mobile. They expect to be mobile, and they're going to take their information with them. And if they can't access it securely and remotely, they're going to carry it around with them, and it's more likely to get lost. And so I think that's one of the key benefits that people need to think about. Very often when I'm retained by clients to kind of help them figure out whether or not they can go to cloud, whether or not the regulatory environment in which they operate allows them to, they're asking questions about security and kind of, is this more secure? And they assume that it's less secure because they can't look at the blinking lights on their server or something else. But they always need to do an assessment based on where they're starting from today, not some sort of nirvana. And where you're starting from today in most environments is a whole bunch of people walking around with 32 gigabyte thumb drives in their pockets or around their necks or otherwise with a huge amount of information on it, or laptops that now currently have 640 gigabyte hard drives where you've downloaded all your email through POP, and the hard drive is not encrypted, and that is your most significant vulnerability. There's more data on laptops on this campus than could ever hope to be held in the data center that University ITS operates. And every one of those devices is potentially vulnerable. So any organization that looking at can they go to the cloud, they always have to ask the question, legally can they? And there's in fact a misconception in Canada, in many sectors, that the law says in Canada that you can't allow personal information to cross the border. And usually that is not the case. That's the case in British Columbia, that in the public sector, it's the case in limited circumstances in Nova Scotia, but that's not the case here in New Brunswick. But one of the most important things I advise my clients about is, you know, just because the law says you can doesn't mean that you should, and you always need to, no matter what, start with first principles. Like, get back to the very beginning about what is the nature of this information, what's the nature of your obligations, what's the nature of the risk, and can that risk be managed? And then once you understand that risk, figure out, is it worth it? Do the benefits outweigh the additional risk? And so, I generally, when you're negotiating a contract, you're not having to deal with what is. And in most cases, everybody will say we'll employ industry standard legal or security precautions and things like that. But then in other cases, they'll say, look, we make no warranties about this sort of thing at all. But the key thing, like principle number one, this is from PIPEDA, which actually doesn't apply to most educational institutions, but it's a really good starting point, is that the organization is responsible for all personal information in custody and control. And they remain responsible for that data, even if they hand it to somebody else for processing or for storage or for otherwise. And they have to put in place legal and contractual obligations to make sure that that third party safeguards that information, takes care of it. They can't delegate, they can't hand off that responsibility. The organization that had it in the first place is responsible for it. But they have to make sure that the service provider is legally bound to protect it in the same way that they would. So what role does jurisdiction play in this? And what role does that play in your obligations of security and otherwise? And generally speaking, it's not the roadblock that you've necessarily been led to believe it is. And we have, in some provinces, and I'll talk about the background to this a little bit, some provinces where they've enacted pretty strict rules that prohibit the export of personal information, like Nova Scotia, British Columbia, and to a much lesser extent, the province of Alberta. And the concern is this, the USA Patriot Act, kind of the elephant in the room, the thing that dare not speak its name, the USA Patriot Act, which was enacted just a couple short months after the terrorist attacks of September 11th, 2001. And what's interesting about this act, it's as thick as a phone book. Now, nobody can write a statute within the space of a month, a statute that is that thick. That was obviously sitting in somebody's bottom drawer, just waiting to come out and be passed. But what it does is it did not create a whole new national security state or a whole national security apparatus out of whole cloth in the United States. What it did is it tweaked a number of things that were already pre-existing, that were generally focused on spy versus spy stuff, and widened the door to allow them to deal with anti-terrorism and certain kinds of criminal activity. And so it deals with things that are so mundane as something called roving surveillance, which is the fact that if the federal government, if the FBI gets a wiretap order against a suspected spy or a suspected terrorist, that wiretap order is only good for the circuit of the federal courts in which the thing was obtained. So if the suspect started in New York and then moved to California, they would have to start from scratch and get a new warrant in California. A roving surveillance order is a federal court order from the Foreign Intelligence Surveillance Act court that says, look, if you've made enough of a case to wiretap Joe Blow, not the suspect number one, whatever, that wiretap order is good all throughout the United States. So a relatively mundane kind of procedural sort of thing. But the thing that actually kind of came to the fore that attracted a lot of attention is this thing called the Foreign Intelligence Surveillance Act, which is a statute that had existed since likely the 1970s. Because if the FBI wanted to wiretap the Russian embassy, they didn't want to be making an application for a warrant at a normal court. They wanted a more secure court. And so they dealt with only foreign intelligence sorts of things. And so they established, the US government established something called the Foreign Intelligence Surveillance Act Court, which is a secret court that meets in a bunker in Washington, that hears applications from only the Department of Justice. It wasn't as though they'd give notice to the Russian embassy and say, do you want to object? And likewise, they don't give a notice to Al-Qaeda and say, do you want to come and object to this sort of application? So they're nothing but ex parte orders. Every single application but one has been granted in this particular court. The composition of that court is public, but their meetings are never in public. They're in a bunker, and you could never get access to their records. And the FISA court can order anybody to produce any tangible thing that's relevant to an investigation. And that any tangible thing can be a piece of paper, it could be this glass of water, it could be a computer, it could be a server, it could be data on a server. And so that's kind of scary that there's a secret court that can issue orders requiring a third-party service provider to hand over that sort of stuff. But at least it's reviewed by a court, an impartial third party. And so what the USA Patriot Act did, it just generally extended spy versus spy powers into what had otherwise been criminal investigation powers. And in some cases lowered the threshold that was required in order to get these sorts of orders. Now, what the big concern is that these laws, these US laws, will apply to US companies, maybe subsidiaries of US companies, any US person within the jurisdiction, any US citizen, and would apply to anything within the borders of the United States or any data within the control of a US person who's subject to this jurisdiction. So it has the potential to tentacle out, to reach out everywhere, just in the same way that if you have a car that's registered in New Brunswick and you cross over the border into Maine and you hit somebody in a car accident, it's a classic conflicts of laws issue where the laws of Maine are likely going to apply, even though you're a Canadian person and that's Canadian property. Your relationship with your insurance company is going to be governed by New Brunswick law and the New Brunswick Insurance Act. So you can, in many mundane circumstances, you can have a mess of overlapping laws. It's just these are relatively complicated and esoteric sorts of laws. So, because generally, a country can take jurisdiction in a number of ways. And so information that leaves Canada is at least going to be subject to the jurisdiction of multiple places. Now, information that stays in Canada that's in the custody of a non-Canadian could be subject to the laws that govern that non-Canadian party. And so the concern is that the US Patriot Act is going to govern, and the US Patriot Act is nasty, and it's going to affect the privacy of Canadians. And so in May of 2004, when the British Columbia government proposed to outsource Medicare claims processing, the BC Government Employees Union flipped out and said, how can we stop this? They didn't want to lose the jobs, and they focused on the privacy angle. And so they had a really comprehensive campaign. These are some kind of billboard ads and bus stop ads that said, if you allow this outsourcing, kind of Uncle Sam is going to get to go trolling through your Medicare claim stuff. And the British Columbia government just doesn't care about this sort of stuff. Your privacy is going to be invaded. And so we're just handing this over to the commercial, industrial, national security apparatus of the United States. And the BC Privacy Commissioner had an inquiry that said, you know, this is a concern, but was not quite as hysterical as everybody else. But in the result, the British Columbia government amended their Freedom of Information Protection and Privacy Act that says, for public bodies in BC, thou shalt not allow any personal information to be exported or any personal information to be accessed from outside of Canada. Full stop. That's the rule. Which means that no public sector body in British Columbia, without violating the law, can use cloud services. I remember being contacted by an elementary school in British Columbia that wanted to have like a grade 5 social studies project to create a blog about the BC Olympics, about the Olympics that were taking place in BC. And somebody said, no, you can't do that. And they contacted me and said, you know, unless you can ensure that it's hosted in Canada, you can't. And the stupid thing is that information is going to be posted on the public internet in any event. It's a bit of an overwritten law that in fact they've had to amend because they discovered that they'd written it so broadly that no BC government department could ever accept credit cards. And when you hit them in the pocketbook, they quickly relented on that one, but not on any other aspects. Alberta kind of came to a pretty sensible approach, pretty pragmatic approach. They said, well, what's the problem? The mischief is a foreign demand for disclosure. We don't want people handing over data in response to a Section 215 order from the FISA court or a national security letter or any of these other things. So let's just make it an offense to hand over. And so if you're an American service provider and you receive a national security letter, you have to say, okay, am I going to violate US criminal law or am I going to violate this Alberta rinky-dink statute? And so it's much more window dressing, but it says, you know, you could be liable up to about $1 million or something else like that. Whereas the violation of US kind of telling the FBI to go stuff it probably has greater consequences too. But it's fundamentally window dressing, but at least it goes closer to the source rather than saying kind of categorically, thou shalt not let information out of the country. Well, Nova Scotia has followed in BC's steps. but not as flagrantly or as flamboyantly. They've done it in a way that allows, that the general rule is thou shalt not allow personal information outside of Canada, or thou shalt not allow access to personal information from outside of Canada. And it even says that thou shalt not take a BlackBerry or a Playbook or an iPad or whatever across the border if you're a government employee or a university employee and it has personal information on it, unless you get the specific permission of the head of your public body, which would be the president of the university. And some of these don't even recognize the fact that if I send an email from my Eastlink account in Halifax to my wife's Alliant account, 1/3 of the time that email gets routed through the States, even though it's going from one computer in my house to the other. And so information crosses the border all the time. You can put these rules in place, but you're not necessarily going to be able to stop these sorts of things. And so, but the Nova Scotia statute says, thou shalt not export or allow access, but it does allow the head of the public body to say, you know what, in the circumstances, this is necessary for our operations, or it relates to our necessary operations. And so we're going to allow it under certain defined circumstances. And so there is a bit of a reality check, which requires, which is what I would plead for, going back to very first principles saying, what's the nature of the data? How sensitive is it? What are the risks? What role does jurisdiction play in that risk? Can those risks be managed? If on balance the benefits outweigh the risks, well then let's go ahead. Or how do we fine tune it? So in Nova Scotia, the head of the university can make that decision and has. One thing that I find absolutely absurd and comical is the fact that if the law is thou shalt not hand over information to these nasty law enforcement people and national security spooks in the States, our law in Nova Scotia that says thou shalt not export allows export to another law enforcement agency in a foreign country under an arrangement, a written agreement, a treaty, or an enactment of the province, the government of Canada, or the Parliament of Canada. What's interesting is, this is where I put my kind of legalese hat back on, under an arrangement or a written agreement, which means that an arrangement is not a written agreement. An arrangement is a nudge and a wink. An arrangement is the sort of circumstances under which Mayor Arar's information was handed over to the FBI and he ended up in Syria. So if you're really serious about wanting to kind of block the flow of this information, you don't allow the people who are kind of doing it most egregiously to continue to do it. But anyways, that's beside the point. So anyways, New Brunswick has not done anything like British Columbia, Alberta, or Nova Scotia, which means that New Brunswick has to think about what their obligations are, think of the risk, think of the role of jurisdiction, those sorts of things. Universities are subject to the Right to Information Protection and Privacy Act, which puts positive obligations on the university to safeguard the information. There have been some suggestions, for example, that UNB isn't the first university to do this. Lakehead University did it, was one of the very first ones to go Google, and a faculty member grieved it, saying that it violated his right of privacy because it would allow this information across the border, and that violated the collective agreement. And the arbitrator said there's no right to privacy in the collective agreement, and so didn't have to go any further. In Alberta, Alberta has gone Google, or is in the process of going Google. They carried out a privacy impact assessment that was reviewed and approved by the Information and Privacy Commissioner of Alberta, who's a pretty level-headed guy. And again, the process of doing this requires what the University of New Brunswick has done, which is to look at the nature of the information, the sensitivity of the information, and this university has decided to go with a hybrid model, which is to student email fully into the cloud and a hybrid model on campus for faculty and staff, with the possibility, as I understand it, as time goes by, for faculty and staff members to individually choose to move over to the cloud-only model if that's what they'd like to do, and to also permit students who don't want to be in the cloud to opt out and go with the hybrid model. But one thing that I want to emphasize, and I know that I'm probably running out of time, and I want to try to leave an opportunity for questions and discussion as much as possible, is that, if our concern is the USA Patriot Act, it's worth understanding what's the circumstance in our own backyard. And what's the situation, because everybody's heard USA Patriot Act, everybody's heard about the FBI, but very few people, generally speaking, are aware of what is the situation in Canada. And then also, what is the amount of information that's shared between the RCMP and the FBI and CSIS and the CIA and everybody else. Well, we have a USA Patriot Act. Well, I guess you could call it a Canada Patriot Act. We have something called the Anti-Terrorism Act, which came into force on December 24th, 2001. Happy Merry Christmas, Canada. That did things very similar to the USA Patriot Act. It amended the Criminal Code, it amended the CSIS Act, and it amended the National Defense Act. It expanded the ability for CSIS to get warrants and others, the RCMP, to get warrants under the Criminal Code. But if the cops wanted access to an email message, they would have to get a warrant in order to do that. If they wanted to get access to an email in transit, they would need a wiretap order, again, a court order. People are very few people understand that we in Canada have a secret court. We have a secret court that meets in a bunker on O'Connor Street in Ottawa. It is composed of judges who are designated judges under the Federal Courts Act and the CSIS Act. It's just like the FISA Act court. They meet in secret. They read secret files and applications for warrants. And actually the powers of our courts under the CSIS Act are even broader. It explicitly allows them to grant orders to CSIS to enter any place, to search, remove, and examine anything, to install, maintain, or remove anything, which essentially, if you read between the lines, it allows them to kind of break in covertly, install bugs, and then sneak out. And then it allows them specifically to go in and replace the batteries in the bug, and then sneak out. And then to, if they have to, I don't know, upgrade to bug 2.0, they can go in and do that. But it also allows them to remove anything, so take your server, take your filing cabinet, photocopy it, clone it, and put it back or whatever. And there's also warrants against third parties to hand over stuff. Usually don't think that kind of Canadian Mounties and Red Surge are involved in these sorts of things, but they are. That's just the simple reality. We also have an equivalent of the National Security Agency, which is the Communications Security Establishment of Canada, that likely intercepts most international communications. You've probably heard about the warrantless wiretapping scandal in the United States. We have the same stuff happens in Canada. The same authority under the FISA Act that would allow kind of intercepting international communications exists in our National Defense Act that allows our Minister of National Defense to allow tapping of international communications. I actually heard somebody say, and I think this is actually somewhat sensible, the charter doesn't apply outside of Canada. So Canada can collect whatever information it wants outside of Canada. The U.S. Bill of Rights does not apply outside of the United States. And so the U.S. government can collect, and they do through satellites and otherwise, suck up as much information that they can. And there's been allegations that the National Security Agency intercepts most submarine transatlantic and trans-Pacific cable traffic. Okay, assuming that's the case, but information that's sitting on a server in the United States requires a subpoena or other legal process. Information is actually more secure in the United States than it is otherwise. And I'm not sure if I buy this 100%, but as long as information in transit where it can be easily intercepted without a warrant is encrypted, which is the case with the Microsoft Live at EDU, or is the case with Google products, or anybody else using a modern Hotmail or Gmail or anything else, HTTPS, it's not readily intercepted. And that's when it's actually most vulnerable. If it's sitting on a server, it's at least going to require some legal process to have somebody hand it over. So we have a very similar situation to us in the United States under the Patriot Act, and we also have a massive amount. Most modern democracies have a massive network of information sharing about criminal investigations in law enforcement and terrorism investigations. So that data goes across the border in any event. Then we have something called an MLAT, a Mutual Legal Assistance Treaty. And we have an MLAT treaty with the United States. We have one with Britain and France and Italy and probably you name it, most of them. Which says that if the FBI wants something that's in Canada, they knock on the door of the RCMP gets a warrant, collects it, hands it over to the FBI, and the FBI do what they want with it. And vice versa, if the RCMP wants something that's in the United States, they ask the FBI gets it and hands it to them. And so it's already, the border, at least in this electronic age, and in this age of post 9/11 national security stuff, is relatively porous, if not completely porous. And so there's a reality that one needs to take into account, that if you're concerned that somebody, law enforcement or national security, can get access to that information, they can get access to it on either side of the border. And so in order to properly determine really what is the difference about information being in Canada or in the United States, it's likely which court system they have to go through in order to get it, which rules of court have to be followed, which rules of criminal evidence and criminal procedure have to be followed. It's likely accessible. But at the very beginning, kind of you need to, and I've said this a couple times, you need to get back to very first principles. Whoever is the original custodian of the data remains legally responsible for it. And they have to make informed decisions about how they're going to handle it, how they're going to manage it. Part of it is going to be privacy against unlawful access, so securing the information, privacy vis-a-vis lawful access, like search orders, search warrants, subpoenas, and things like that. And part of the analysis is going to be, what's the nature of the information? Is it information that's really sensitive, the disclosure of which would significantly harm the person that it's about? Is it information that is likely of interest to hackers on one hand? Hackers are a significant security threat. Is it the sort of information that would likely be of interest to the FBI or the RCMP or any of those other guys in trench coats, which would raise the risk or the likelihood that somebody might be looking for it? And then what's the likelihood, how are the different ways of safeguarding it? If it's really of interest to the RCMP or the FBI, regardless of where it is, they're going to get access to it. If it's very much of interest to the Chinese, they're likely going to try to hack into it. Their legal process won't work in Canada, and their legal process won't work in the United States. And no legitimate service provider is stupid enough to put a data center in China or North Korea or Namibia or Libya or otherwise. And so those are the sorts of things that need to be thought about. And then once on balance things have been, once you have a clear picture of what the risk is, you need to find steps that can be taken to mitigate that. And allow people to make choices about how their information is collected, used, and disclosed. And so if the risk is high and you can't assure the safeguards, well then the answer may in fact be no. If the risk is low, but you can mitigate, and whatever risks there are can be mitigated, then the answer is likely yes. But the important thing is to go through the process, understand all of these factors, understand the legal environment on both sides of the border in order to make as informed a decision as possible as you can about these things. And so there are a number of things that can be built into and obligations that can be put on the service provider. You'll never get all of these, but these are things that can be asked for, can be sought out. But most legitimate service providers, for example, will say that they're only going to use your information for your purposes. Some people actually have concerns or misconceptions about the fact that they kind of see ads on their Yahoo Mail or their Hotmail or their Gmail, and are concerned that kind of some companies trolling through their messages, which if they are, it's only in a really automated way. No individual has access to those messages. But you're going to want to say, look, because I'm obligated with respect to this information, and I'm giving it to you to provide me with a service, you're only going to use it to provide me with the service and for no other purpose. And Microsoft and Google and Oracle and Salesforce are going to say that. They may want to, and in most cases will, they want to have information about how many users use it. They want to know, they want kind of analytics about how if you have a document word processing system and you have 500,000 users and you know that none of them use this particular feature, the provider wants to know that. But that's anonymous information, so that's a different kind of kettle of fish. I will often ask, if I'm acting for the consumer or the customer, that the information is held in trust for the customer. Very seldom will they agree to it, but they will often acknowledge that it is the customer's data, that the service provider has no proprietary interest in it, has no other interest in it, and in fact will return it at the end of the contract. No disclosures of information without your consent. Most often you'll see that just about all these contracts will say that they have the right to disclose information where they are legally obligated to, which requires you to think about what are the circumstances under which they're legally obligated to. In some cases you can ask, but in very, very seldom will a service provider say that they will lawfully resist to the extent possible any disclosure. In most cases they'll say, if somebody comes to us and says, here's a subpoena, we want access to that particular customer's data, they will, if they legally can, tell the customer. For example, one large service provider says in their contract, as a matter of policy, that they'll tell whoever it is that shows up with the lawful demand, says it's not our data, go talk to our customer, which could work in many cases, but won't necessarily work. But there's some processes, like a Section 215 warrant, which says that the service provider can't tell the individual concerned, and so one could ask, and in some cases you'll seldom get it in writing, but they'll say, yeah, well, if we're able to or if we can, we will try to resist it. Which you can't contest a warrant. Somebody shows up with a warrant, all you can do is step aside, a lawful warrant. But somebody shows up with a subpoena, you can go back to the court that issued the subpoena and say this is overbroad or inappropriate or otherwise. And so if you can get your service provider to resist it, that's a good thing, obviously, to do. Liquidated damages for any disclosure without consent. This means attaching a dollar value in advance to what a disclosure without consent would involve. Because it's very difficult after the fact to put a dollar value on what that is. But it's similar to a service level that says, look, if you've disclosed information accidentally or otherwise, or one of your employees took off with it without our consent, we're going to be harmed. And so if that happens, you're going to pay us a penalty of X dollars. An obligation to cooperate with you in any regulator's investigation. So the privacy commissioner comes knocking and you need to provide them with information, audit logs or otherwise, that your service provider would have an obligation to help with that. But you don't want them dealing with your regulators on your behalf because it's your head on the line. Implement safeguards to protect information. Most, Microsoft and Google, will tell you about the safeguards that they implement. They'll tell you that they're at least industry standard. For example, Google is NIST certified and FISMA certified and other kind of ISO standards. Microsoft likewise will give you a full rundown of what their security precautions are and will stand behind it, which is obviously a good thing. On the consumer level, the free level, they're not going to. Obviously not. Why, if they're giving you something for free, why are they going to kind of put their necks on the line? But when it comes to these enterprise level arrangements, they will. Don't accept any limitations of liability related to privacy and security, full indemnity. So if something goes completely sideways, they violate the agreement with respect to security or privacy, they're completely on the hook. It's not limited to the license fees or otherwise, which is the usual metric in a consumer sort of contract. And then obviously no retention of your information. If you sever your ties with them, you want to make sure that you can walk away knowing that they don't have any information that can then be compromised. One thing that's worth noting is that the service provider in most provinces is not subject to these privacy laws. The Right to Information and Protection of Privacy Act in New Brunswick applies to public bodies and educational institutions, not their service providers. In some provinces, the service providers are kind of sucked into it. But it's not their legal obligations. Ultimately, it's your obligation. And to the extent that you can, the institution needs to push those obligations, but can't push the responsibility, the legal responsibility, onto the service provider. Because when it comes to things like protecting, essentially safeguarding that information, one of the reasons why you're going to that provider is because they can do it as well or better than you, but you want to make sure that they're actually committed to it. And also one thing that a lot of educational institutions have gone through a process thinking about is to what extent do provincial privacy laws apply to different kinds of information. Provincial privacy laws likely do not apply to student information in a student email account because they're not an agent of the government. They're not an agent of the university. That is their email inbox that might sit on a server right now operated by the university, but it's not a record of a public body. It's not a record of an institution. So it may in fact be that these privacy laws don't apply to their email because it's something that once they're set up on the account that they control. There's also been some argument by the Canadian Association of University Teachers that in fact faculty email is not under the control of the institution, which remains an open question. But when it comes to where these obligations lie, those are important considerations. Quick note about copyright, that in these cloud agreements, for example, in the agreement with Microsoft, their standard Live at EDU agreement, they don't take any proprietary interest in any information generated by faculty, staff, or students. It has no impact whatsoever on who owns that data, who has a right to do it. To the extent that there is a license that they take, it's a license to provide the service to you, and that's it. And so ultimately, even though the Canadian Association of University Teachers has raised it as an issue, at least in the Live at EDU contracts that I've seen and the Google contracts that I've seen have in fact no impact on anybody's intellectual property rights. Particularly faculty intellectual property rights to inventions, copyrights, and in their lectures and stuff like that. So, thank you very much for your time and attention. I would be happy to answer any questions that anybody wants to fling at me, and I'll give it a shot.